Appeals Court remands Scott Perry's speech or debate clause case back to District Court. Welcome to Law and Society. Today we're going to talk about Scott Perry's speech or debate clause privileges. I uploaded a previous video in which I talked about how the appellate court ruled in favor of Scott Perry. That's not entirely accurate. After I went back and read the case, I realized that this was a remand. So it wasn't a reversal. There's a big difference between a remand and a reversal. So if you're new to my channel, please like and subscribe. We're going to discuss these fun legal things. Because, our democracy matters, and the rule of law matters, and I believe that everybody, whether you've been to law school or not, whether you understand the law or not, you are entitled to the truth. So what I attempt to do here is to boil it down for you as simply as I can and be a bridge to all the legalese that surrounds us and that does impact us on an existential level, though not on a real life, day-to-day level. So let's dive into it. Appellate court held that district court didn't apply the correct standard in assessing which communications were privileged and which were not. To call this a loss for the DOJ would not be accurate. Once the district court follows the appellate court's instructions in this ruling and issues its own ruling in accordance with this ruling, the one we will discuss now, DOJ will have some of the communications from Scott Perry's phone. And only time will tell whether what Jack Smith is able to access will have evidentiary value. So the fight's not completely over yet, but it does limit DOJ's reach, and they don't get anything for now because in the DC circuit, the cell phone and cell phone's contents remain in the court's jurisdiction while the matter is resolved in the courts. And it does limit DOJ's reach, and they don't get anything for now while the court decides what's privileged under the speech or debate clause and what's not. So that's sort of a quick 1-minute summary of the case. Now what I'll do is I will deep dive. So if you're not interested in the deep dive, you may log off now, or you may check out now. I very much appreciate your time up until now, and please like and subscribe. It really helps with my algorithms. I don't know what an algorithm is, but it somehow helps get my videos out to more viewers. So thank you so much, and let's get back into it. So I will read excerpts. Here, we're starting out with this case that remands the Scott Perry cell phone case back to the district court with instructions. Here are the instructions. Some acts of informal fact-finding, however, might satisfy the Gravel test. So the Gravel test, Gravel, however you want to pronounce it. So we reject the district court's categorical holding that such acts are never legislative acts subject to the privilege. With respect to Representative Perry's communications with executive branch officials and others outside Congress, we remand to the district court to apply the Gravel standard and on a communication by communication basis. On a communication by communication basis. Yeah, I didn't misread that. The district court, however, incorrectly withheld the privilege from communications between Ms. Representative Perry and other members about the 2020 election certification vote and a vote on proposed election reform legislation. These are quintessential legislative acts entitled to privilege, and we vacate the district court's judgment with respect to those communications and remand. It's a very categorical and well explained opinion. I have only taken excerpts from this because I don't want to read you a 30-page opinion, even with a deep dive. When evaluating, going back to the reading, when evaluating whether something is a legislative act within the meaning of grovel, the court will often consider whether protection of the privilege is necessary to preserve the integrity of the legislative process, and whether the independence of the legislator is at stake, and whether the actions at issue are things generally done in the course of the process of enacting legislation. These considerations are important for understanding the scope of the speech or debate clause, and they may help flesh out the application of the grovel criteria to specific facts. So here, the appellate court essentially gives the district court a test, saying when evaluating whether something is a legislative act within the meaning of grovel, the court will often consider whether the protection of the privilege is necessary to preserve the integrity of the legislative process, whether the independence of the legislature is at stake, and whether the actions at issue are things generally done in the course of the process of enacting legislation. So legislature and legislative and legislation in that paragraph should give you an idea that it has to do with Article 1 power of legislation, which is what the speech or debate clause privilege is meant to safeguard. First, the privilege includes immunity from suit. A member may not be sued or prosecuted for his legislative duties. Second, the privilege includes an evidentiary privilege. Legislative acts may not be introduced into evidence even when the government seeks to punish a member for non-legislative acts. Third, the privilege encompasses a testimonial privilege not to be questioned in any other place. This means that only Congress, not the executive or judiciary, may force a member to testify about legislative acts. So remember, legislative acts. There may be communications in Scott Perry's phone that is not legislative acts, and we're getting to that. It is possible that some communications within the informal fact-finding category could be privileged, and therefore we disagree with the district court's holding that informal fact-finding is never a legislative act. But we also reject Representative Perry's proposition that informal fact-finding is always a legislative act. In assessing whether the privilege applies, the Supreme Court and this circuit undertake a fact-specific inquiry under grovel, because the district court is better positioned to apply the correct fact-specific inquiry in the first instance. We vacate and remand this part of the order. So, as it goes to informal fact-finding category, that informalness has to be decided on a fact and a circumstance and a case-by-case basis. So on specific messages sent, each one of them, you have to go through them to see whether the privilege applies or not. And this is categorical. And this court really chalks it out for the lower court how to go about this. Water break. So if you are new and you have landed in the middle of this conversation, I am doing a deep dive of the Scott Perry cell phone case that was remanded from DC Circuit to the district court with instruction on how to apply the grovel test. I think I have settled on grovel as the pronunciation. In order for an activity to be considered essential to legislating, it must be an integral part of the deliberative and communicative processes dealing with the matters within the jurisdiction of Congress. In applying these principles, we found that some acts taken pursuant to the investigations were protected and others were not. In light of reasoning in Eastland and McSorley, this precedent, and other cases, we reject the district court's holding that all informal fact-finding is excluded from the protection of the privilege, and that fact-finding must have formal authorization before the privilege may attach. Formal authorization is neither necessary nor sufficient for the privilege to attach to the wide range of activities that could be denominated investigative or fact-finding. Rather, the Supreme Court and this circuit considers the specific facts to determine whether a particular action is a legislative act within the test articulated by grovel. Representative Perry maintains all instances of informal fact-finding within grovel's first category is privileged. Informal fact-finding, now the court says, informal fact-finding is an amorphous category, and Perry's briefing is unclear that what precisely would be subsumed within this term. Some instances of informal fact-finding might be privileged, but at least some acts of Representative Perry considers to be informal fact-finding have been held to be outside the coverage of the clause. His categorical claim for the privilege therefore fails. So you see, this is an instruction to the district court of how to go about dealing with this case, and each of the messages have to be dealt with on a fact-specific basis. I think we went over that when we were talking about the speech or debate clause before, and this district court ruling was a wide net, and the appellate court is now drawing that net back in. A reversal would have been lifting that net out altogether, okay? So just to give you an idea of the difference. So when you hear in the media that appellate court shields or appellate court rules in favor of Scott Perry, that's not accurate, okay? And I myself am saying in my previous video, saying that appellate court ruled in favor and talking about appeals is not accurate, because this goes back to the district court according to the instructions of this appellate court. Not all communications, going back to this ruling, not all communications that may influence a vote are privileged. Rather, the proper test is whether such communications are integral or essential to the deliberations or otherwise satisfy the requirements of grovel. But under grovel, the clause does not protect acts that are not legislative in nature, even if they are performed in a member's official capacity. The fact that informal fact-finding is consistent with a member's official duty to legislate wisely does not necessarily mean that such acts are privileged. Representative Perry's attempt to shoehorn a novel and broad category into grovel would pull the Supreme Court's doctrinal framework out of joint. That's a strong language rejecting Scott Perry's carte blanche privilege assertion. Because the district court applies the incorrect legal standard, we remand the privilege determinations over categories 1 and 3 for the district court to apply grovel on a communication by communication basis. So it's going to be grueling and it's going to take time, but this is how you ensure due process of law is served. The district court also determined that some of Representative Perry's intra-congressional communications were non-legislative. They included electronic newsletters insofar as they merely discussed upcoming events, political talking points, news articles of interest, and non-legislative events occurring in and around Congress. We agree these are far too removed from legislative proceedings to warrant privilege under the clause. So here we have the appellate court agreeing with a portion of the district court's opinion. It follows that Representative Perry's discussions with his staff about press coverage and his media strategy are also not privileged legislative acts. These strategic discussions are at least as removed from the deliberative process as the unprivileged communications in Hutchinson, which is another court precedent. The government may view records of these communications. We disagree, however, with the district court's determination that discussions with other members about alleged fraud in the 2020 presidential election were non-legislative. The district court inadequately considered the context of these conversations, which involved member deliberations about upcoming votes. Some of the communications took place shortly prior to Congress's scheduled January 2021 vote on whether to certify the electoral results from each state. While elections are political events, a member's deliberation about whether to certify a presidential election or how to assess information relevant to legislation about federal election procedures are textbook legislative acts protected by grovel. These communications were privileged, and we leave it to the district court to implement this holding on a communication by communication basis. Mind you, this is not a shield that the District of Columbia Circuit has done for Scott Perry. This is honing in and more laser into what was said and whether it falls into legislative purpose or not. The district, but the appellate court is also even-handed in telling the district court misapplied and didn't, rule properly in doing a broad sweep ruling either. The district court failed to apply the fact-specific privilege inquiry under grovel. Therefore, we vacate the judgment in part and remand for district court to apply the correct standard, consistent with this opinion. With respect to the remaining privilege determinations about Representative Perry's communications with members of Congress, we affirm, meaning any other portion that has left, any other communication that is not specifically mentioned in this 29-page opinion, then those communications, district court ruling in covering those, that privilege doesn't apply, is affirmed by the appellate court. So that is the ruling. I'm not going to read the concurrence. because that is more academic and not does not have a sort of binding impact on the district court, and it's just more. If you've already gotten to 20 minutes and you're still here, I thank you very much. I don't want to bore you with more jargon, but I will tell you that DOJ will not get Scott Perry's cell phone information now, but this case is being remanded back to the district court to go on a fact-specific, communication by communication basis to see whether the privilege, speech or debate clause privilege, applies specifically to each of the communications. And that is going to take the district court whatever time it takes the district court. So this ruling was unsealed, and so we know it's happening. So we're not going to know what the district court is going to do, because that will likely be sealed, and then the 11th Circuit will probably look at it again. If Scott Perry appeals it again, which I imagine he will, they will see, and they will either affirm the district court's ruling in conformity with their ruling in this case that I just read to you. And if they affirm, that means Scott Perry would then have the opportunity to appeal to the Supreme Court, at which point Scott Perry's case will be weak, and I don't believe that he will take it to Supreme Court. But, wilder things have happened. This is a very weird legal dystopia that we're living in. Very weird constitutional sort of limbo that our country is currently a part of. And I want y'all to be aware of it as much as possible. So thank you so much for sticking around for this long. Please share, please subscribe, and if you've liked the content, please like. I'll see you soon.